The tape is running.
Yeah. Okay, everybody, if I have your attention, 7:30, so I'd like to call the July 15th, 2013 meeting of the Planning Commission to order. And the first item is a roll call. Ms. Roll.
Art Khan,
Here.
Darrell Lewandowski,
Here.
Casey Kelly. Here. Doug Shepherd,
Here.
T.J. McLaughlin. Here. Pam Merlo. Here. Sandy Petrosky. Absent.
Absent, and she had a last-minute scheduling conflict. Okay, we have a quorum, and so at this point, I'll entertain a motion related to tonight's agenda, if someone would care to make one.
I'd like a copy of the agenda. I thought I had a copy and I don't.
Okay, we'll get some agenda copies here. We'll wait for the planning commissioners to see it, and then we'll see if we can agree that it's the right agenda.
That's June. Thanks, Bud. Thank you.
The agenda?
Okay.
Well, I'll make a motion that we approve the agenda as submitted. Is there a second?
Second.
All those in favor, say aye.
Aye.
Aye. Motion passes. Okay. Before we start public comment, basically we have a couple little things, but really we have an old business item, which is working on the text amendment to the draft zoning ordinance. As a follow-up to the public hearing that we had last time. And so what we're going to do is we're going to continue the procedure the way we had it going, which was we had already received a large amount of public comment, and of course we've done that over many meetings. So when I open up, when we get into the business discussion, my intention is not to have back and forth debate with the public at that point in the meeting, because I believe we've had ample opportunity for that. So if you're here and you want to make some point related to the draft zoning ordinance, I would like you to consider doing that during the public commenting, which is going to be the next item in the agenda, or you can comment at the public comment period at the end of the agenda. But I don't think there's a need for us to plan on a back and forth discussion during the business item, but rather we'll focus on the dialogue between the members of the Planning Commission and the professionals that are here to service. That doesn't mean we won't change if something important happens, but that's our intent. So at that point, we'll go to agenda item number 4, which is public comment. Mr. Horton. Good evening.
Bob Horton, 4235 Shoreview, Whitmore Lake, Michigan. That's the only thing on the agenda is that, so there's no discussion when we hear from the from the consultants. What if we don't agree with what he said? I'm just asking. What if we don't agree with it? We have to wait to the end after you pass it? It doesn't make any sense. In other words, if you go to number 8 on the old business, once you go by it, you would have made a decision. Yes or no? So then we're going to get down to the end. There's no sense standing up and discussing. Something's already passed or rejected or whatever. It doesn't make any sense. Especially when it was an open meeting and it didn't get all done. That's it. It just kind of doesn't make that much sense.
Okay. Ms. Hamilton.
Just like to thank Don in the minutes for conciseness as to what the Planning Commission agreed to by consensus for the changes that were suggested by the public at the last meeting. It was very clear, thank you.
Okay. Anyone else?
small reminder that we've discussed several items about the industrial district, and we've a lot of discussion on the outdoor storage. And I just want to remind that there's a lot of people opposed to, possibly parking a bulldozer next to the fence on people's lot. And we're concerned about the quality of living for residents in the industrial district. But yet, just a couple hundred feet from a lot of these residents, we have a giant mountain of garbage where a couple hundred trucks a day run in and dump garbage. And yet, no one really seems to be concerned about the pile of garbage that's there. I mean, if we're really concerned about these residents, maybe we should be checking their groundwater, seeing what they're drinking. Is it affecting their air quality? I mean, it's not exactly the best life to be living next to a giant landfill. So, and it seems like there's more offense taken to the storage of equipment outside than there is to a mountain so high that you can see downtown Detroit from the top. And I'd also like to remind you that, there's an opinion that we've been given a lot during these discussions, and we have gained some advantages. But by allowing us to build a building another 20 foot, is that such a horrible thing? If we build a building, if it just that much encourages some guy to build another building there, that generates tax revenue. That helps some other kid go to school, it helps pave the roads, and God forbid we might hire somebody and give them a job. So that's why I just wanted to remind you. Thank you.
Any other public comment? Fine. We're done with public comment this evening. We'll move on to agenda item 5, which is correspondence. I only had one item come up, Michigan Township News for July 2013. And I haven't read it in its entirety. There's a few things that are tangentially related to what we do here. I can share it with the members of the Planning Commission if you want to look through it. If you are really interested in it, you're certainly welcome to go through the copy. All right. That's it for correspondence. You didn't have anything else, did you, Ms. Cripps?
No, sir.
Okay, good. So we'll move forward. We do not have a public hearing tonight. We do not have new business. The next item is item 8 on the schedule, which is old business, which is item 13004, text amendment for the draft zoning ordinance. And we had our public hearing last month. And as we got to the business item, I'm just going to remind everybody where we were to try and get you anchored. And then I have a suggestion of how we'll get through this, because we've got plenty of time, and this is a very large technical ordinance that we need to make sure we're happy with, although you would think after working on it for 39 months that someone on the Planning Commission would be happy with it. But again, when you do something really good, it takes a lot of work to get it right. So anyway, we agreed that to establish an orderly majority approval process for revising the draft. And we started that in the business discussion last time, and so we need to continue that, okay? And then where we were in a process where we were entertaining commissioner questions regarding the zoning ordinance content and proposals from the commissioners for revisions. And we had used some of the input from the public as ideas and followed up on them there. And then there certainly in the 4 weeks we've had opportunity to study, and so we may have more questions and such. We've also had a couple documents come to our attention. The first one we'll mention is an article that came from the planners, and there were 1, specific questions that they addressed. I'm going to ask them to highlight those questions and just the responses in general so that the public will understand the information that's been made available. And then we have a follow-up note from Ms. Petrosky related to that. And since she's not here, I'll do my best after we've had the first discussion. I'll do my best to highlight a few of the things there so that we have that information out in front. And then we're going to just go into questions from the commissioners and see if we can get to the point where we're ready to determine going forward, are we done at the planning commission working on this ordinance, we want to send it to the township, or do we discover some things that need further work? And what that further work is in scheduling it. So that's what we're going to do here tonight, okay? So at that, why don't, I don't know if Mr. Pennington or Mr. Nanny would like to run us through this document, but it was a very good, there were some very pertinent questions about the current zoning ordinance and how it relates to past zoning ordinances, and I'd like that to be shared.
Okay, I'd be happy to just kind of walk through and highlight a few things. This is all from our report on June the 9th. The first question that came up was related to tracking of changes from the current ordinance to this new proposed ordinance. And from the very beginning of this process, there was a recognition that we were going to be reorganizing this ordinance. We put in the land use table and a number of elements of the ordinance are organized differently from the current ordinance. And as a result of that, it was difficult to track, to simply show, strike through and underline, this is what we're changing from the current ordinance to the new one. And so the goal of the initial draft document that was provided was that was a clean copy. It did not generally show those changes. And then through the discussion with the Planning Commission, where there were changes being made from the policies in the current ordinance, so that they were discussed. And so from each of the drafts since then, whatever changes the Planning Commission identified, those were shown in the strike through and underline text as related to the immediately previous draft. And so, I mean, just as an example, the material we have tonight, this set of replacement pages are dated July the 5th that we'll be talking about. Those changes that are noted there, the clean text is the public hearing draft from May, and then the changes are the July changes. So we've carried that process through from the very beginning. The second question was related to the material that was provided a while back, it was a packet entitled Article 35, which were the special districts that had been adopted back in 2005 for the urban service area down at M14 and Conference Road. And the question was, where are those elements in this draft? Because of course we didn't even have that Article 35. It was missing from the codified document. So how did they get into this draft? And the answer to that question is essentially that when we looked at putting this draft together, we went a different route anyway from what Article 35 was doing, in that we proposed a new zoning district called the Urban Services District, and it was intended to function as the special district for that area there at M14 Conference and Road. And the language in the proposed ordinance for that Urban Services District was very specific in that it tied directly back to the master plan. One of the benefits we have is we have what's still a relatively new state zoning act and a new state planning act, and those new acts at the state level much more closely tied together zoning and the master plan, making the master plan that much more a legal foundation under the zoning ordinance. And so we were able to use that language that's in the state act to create this special district. And so it would essentially replace the commercial commons park and some of the other language that's in Article 35, but did not replace the standards that are there. In that Article 35 document, there were some excellent design guidelines and standards related to how properties should be developed there. And a lot of that language actually ended up as general standards in the ordinance. Exterior lighting provisions that would apply for any development project, not just a development project in that area. Natural features protection that was broadened and put in to cover any development project in the township. And other elements like that were carried over into the general ordinance. So none of those design guidelines were lost. They were just brought into the ordinance in a little different way. The only thing that happened with that changed in this public hearing draft was the decision that was made to rezone property into the residential office park district. Remember, we had that rezoning process. That's one of those districts that's in the current Article 35. So in the public hearing draft, we added in residential office park special district as its own special district here. And provided the standards that need to be there for that, should any future land be proposed to be rezoned into it. So we've covered cover that material that's in the current Article 35, but in, like I said, in a little different way, actually a way that improves the flexibility of the document and improves the flexibility in terms of reviewing development projects that come in. The third question was related to the other set of amendments that did not get into the codified ordinance as it should have. And that was by the way, both of those sets of amendments were lawful, they were enforceable, they just happened to not be in the document that was online. But they were lawfully adopted into the zoning ordinance and were effective as part of those amendments. In 2007, the township adopted amendments to our current ordinance to deal with the new state law, the new state zoning act that had been adopted in 2006 in Lansing. And the question was, where are those amendments in our new ordinance? Because we did not specifically call them out. And the short answer to that question is the entire ordinance reflects the new state act because we are required to follow them. And so they are simply built into the provisions in the state act. Most of them relate to public hearing procedures and standards related to when notices have to be published and such, but there are some other elements for the zoning board of appeals that are updated. But they are simply built into the new act. The fourth question, the last page of our report, was this question about whether or not this process is a revision to our current ordinance or a new ordinance entirely. And the question relates to at what point are we adopting a brand new ordinance, and that's what this really is. Much of what is in the current ordinance is in this document. It has been, we have updated, we've adjusted, we've made changes and policy adjustments all the way through this process. But certainly the core elements of the current ordinance that functioned and should be carried forward are here. But in terms of how this process works, this is a new ordinance that you'll be recommending to the township board. And if the township board chooses to adopt it, it will be replacing the current document entirely. It's not a revision or an amendment. It is entirely a replacement. And in fact, there's language in this ordinance that there's a section called repeal of previous ordinances that simply says all previous zoning ordinances and any provisions that conflict with this ordinance are repealed. So this is a problem for that effect. This is a new ordinance we are adopting for the township. Let's see, two other questions. The next question, number 5, was about farm-based tourism and entertainment activities and farm markets. The question was, there was some additional language that's in this public hearing draft, the May public hearing draft, that specifically listed a set of land uses that are permitted under this category. This farm-based tourism category, we talked about it previously, is intended to allow farmers in the township that choose to do it to be able to have a little diversified sources of income by having some farm-related tourism activities on the property. And we've had a lot of information about that. What we did in this additional language in particular was in discussions with the township attorney, who has a copy of the public hearing draft ordinance and had reviewed it. He had asked for clarification of this section. He felt that it was too broad, potentially too broad. And he preferred to have a specific list of the types of activities that would be permitted should a farmer choose to come before you and ask for approval under that section. And so that language that was added was based on his comments and recommendations. And it essentially narrowed down somewhat the scope of activities that are permitted under that particular section. The last question was related to the adoption of the ordinance, and that one, we certainly, as was mentioned, we are to that point where the next step for the adoption process is when you're comfortable that the ordinance is ready to move forward, the Planning Commission makes a formal recommendation to the board. It's usually by resolution and a roll call vote, and it recommends the ordinance forward to the township board. There's no outside agency review. In some places there's still a county review, but that's not the case in Washington County because the county's opted out of that. And so the next step is that it would go to the township board, where they would review it as part of their regular meeting. They can hold another public hearing if they choose, but they don't have to. And so as part of their regular meeting, they would review it, and if they're comfortable with it, they would formally adopt the ordinance. And then there would be a notice of publication that would go out, and essentially a waiting period before the ordinance becomes effective. But those are the basic steps then for adoption. Those were the questions that came up. I'm happy to answer any questions you may have about those things.
Okay. And on behalf of Ms. Petrosky, I'll just highlight her comments related to that note. One second. And her first point is that any of the items that came into the draft zoning ordinance that after September 17th should be, our convention was for any changes at that point for them to be annotated as changes. And so the question there is with regard to these items we talked about as changes and additions, were they all annotated properly so that the members of the Planning Commission knew they were changes and we had the opportunity to question them in particular? And so did we miss something? And that's what I don't know.
I think the concern in part was this Article 35, and did that get in there since that came up after September? And the answer is basically that we'd already put together this alternative process for the urban services, new urban services district, as a more flexible solution. So we didn't have to put all that material in. But in the public hearing draft in particular, there you see some of the additional standards from Article 35 that we brought into the ordinance for the residential office park district and for the urban services district, based on the material that's in the current ordinance.
35 in the old ordinance was the urban services district.
Okay.
Right. And as I remember it, that was a complete section substitution from the 2001 or 2 zoning ordinance that became effective in 2005. And to help everybody remember what was going on, it's like it wasn't in the online copy, so it wasn't convenient to find, yet you could get it if you walked in and asked the zoning administrator, which I did at one point about 3 years ago. I got that section, that new section, along with the rest of the zoning ordinance. But you could argue that what was online was a little bit misleading, but I think that's been there all along. And then, am I right in that there was one element, let's say, of oversight from that section that wasn't written into the draft zoning ordinance at the very beginning, and that was the residential office park in the land use table and such.
But it was not an oversight, only that we had intended that to be part of this new urban services district. And the change was basically when we rezoned land this past spring into that district, that we then had to deal with that district separately in this ordinance. So that when this new ordinance is adopted, there still is a district called the Residential Office Park District, and it still has standards that apply to it. And so we simply, because of the decision to put that property into a district that exists in the current ordinance, we carried it, added it through separately in the public hearing draft here.
Okay. And the other, of course, was just continuing to focus on the 2007 revisions. And I think that we'll need to touch on that in another second, right? Another point made here is what were the specific additions added to 40.102A by the attorney? Because they got in there, but I'm not sure. We said, okay, this one came from the attorney, but I know that we knew that was slightly changed when we went through it, and that we actually discussed that briefly as the planning commission.
Yeah, if you look on page 40-3 of this draft ordinance, it is actually the subsection A that was added, 40.102A use standards is what it's entitled. That is the language that was added, and it basically said that these specific land uses are permitted, consistent with the definitions of farm-based tourism and farm market. And those, basically, the uses that are permitted under this section are limited to agricultural festivals and events, farm-based or seasonal recreation attractions, winery or cider mill, farm-based educational center, and indoor or outdoor facilities for group gatherings, accessory food service and retail sales, provided that such facilities are incidental in character as compared to the overall parcel size and scope of the permitted uses of the property. A farm market, as defined in the ordinance, and then similar facilities and activities as accepted by the planning commission.
And so that section was the clarification that came from the attorney?
That's right. He asked for us, asked specifically for a set of land uses that would be permitted in this section. And what we did is we used the recommendations from the State Agricultural Tourism Commission. We saw that material a while back to prepare the language that was proposed here. And then, like I said, when we were looking at this public hearing draft, we did highlight that this change had been made, and it was discussed. There was not a whole lot of discussion about it, but it was mentioned and looked at during our meetings.
Okay. So, and then another point in Ms. Petrowski's letter is Article 45. Apparently there was Article 45 early on, and there is no longer an Article 45. And just remind us what that was.
It was Article 45. There's in the current ordinance. But in the current ordinance, there was an article. It was called. No, this was urban service area, urban service. It was an odd article, and it was essentially carried over from the current ordinance into the proposed one, without significant change. I think we tweaked some grammar or something in it, with the intent of having a conversation about what do we want to do with this. Well, essentially, what that became was we carried over as rural. What is it called?
Rural and urban service districts.
Yeah, and really what this became was the urban services district for the M14 in Goffredson area. What we understood is that was the intent behind it, and so when we looked at revising that draft, we simply carried that language over and put it into the special districts article.
Okay, so the previous zoning ordinance did not have an Article 45.
It did have this
version of this language index for the current zoning ordinance, not drafts of what were complete rewrite. But I look and I don't have anything in terms of an Article 45. So what I'm trying to do is come to an understanding of what that article really was.
What that, like as I said, that was essentially language that was carried over. It's you'll have to forgive me, I don't have the current ordinance in front of me, I didn't look that reference up, but it was, as we were going through the document, that was language that was essentially carried over.
It's not in your current zoning book because it hasn't been codified. That was an article that was passed in 2005, and you were handed a separate copy of it.
So,
The urban
45 or
service
35?
districts. It was the urban service district.
Doug?
Well, but you see, that's not, okay.
That's 2012.
This is Article 45. This was not in the previous, in the zoning ordinance that was in effect today. This doesn't appear, right?
Well, it was, as Donna said, I think it was part of that language that was adopted back
In 2005.
What we found, though, is after we put that September draft together with that article, we found that that was not what was needed to be done. That was not really working for the actual purpose behind the urban service area and the goal of establishing zoning for that area of the township. So that's when we went to the model of bringing that into and creating a new special district called the Urban Services District. And so the Article 45 was no longer necessary. It's folded into and made part of the special district article, which is Article 50.
Okay. You're answering my question as to the content rather than just the procedure and organization. And Article 45, there was no Article 45 in the previous zoning ordinance, correct?
This was
Not the content of it, in Article number 45.
No, there was no Article 45 in the books that you have. This is one of those ordinances that was passed after the adoption of that document that I had placed at the table, that I had come across that was not included in your books.
I understand, but I have
But
what?
it was not part of the 2001 adopted ordinance.
The additions to the zoning ordinance that were not in the online version still did not have an Article 45, they had an Article
it did not.
35.
I see.
Yeah.
The number was related to the
Okay.
reorganization
And
ordinance, yeah. I see.
I understand, now, so I'm okay there, and then what you had here, and you wrote as, that was written into the draft of the new zoning ordinance in Article 45, was to cover a portion of what had been built in related to the urban services district. And then, tell me if I'm wrong, but after reviewing the entire document, when we cleaned up the draft, you found that it was superfluous to have that section because all the elements that were in what was section 45 are in the mainstream document.
Right, that is correct, yes, it was superfluous article, it was not needed, and the provisions are built into the rest of the article, primarily Article 50, which is the special.
Okay, I was just trying to figure out where the reference to 45 came from. It's only in the draft, and between September and May, your review said you didn't need it. Okay. Yes, Mr. Pennington.
Have you seen the Article 45 as it was basically adopted some time ago? Do you know what's in Article 45, the old Article 45?
35, you mean?
No, 45.
35 or 45?
45, we're talking about 45. I just wonder if you have, because it was only 2 or 3 pages long. And the reason for that was very focused when we were going through some of the revisions to the zoning ordinance, as well as revisions to the, at that time, what was called the general development plan, we wanted to make a very specific distinction between what was rural and what was urban. So the 2 pages there make that decision. There's definitions of what is called a rural area, and that was defined as everything that was outside of the urban service district. And there was purpose statements that said that that area was not to receive urban services, public sewer, water, etc. Then the urban service district was defined as the area that we commonly make reference to, which is around Hopkinson Road. The third part of that district was a recognition of the Hamlet area, that it had a very special set of circumstances and character and regulations. That's all that district said, was to make those distinctions. And as Rodney said, those distinctions have been more clarified in the current ordinance, and it's been brought into the current ordinance to basically substantiate what this old 45 article is trying to accomplish.
Okay, so now, as follow-up, just help me understand the concerns that prompted this to be drafted, right? And it referenced a rural and urban services map, right?
Yes.
How are those concerns handled under the existing draft ordinance so that there's not a problem with the submission?
It's all-
If you just elaborate a little bit, I think that'll help us be comfortable.
Well, I think, if you look at our letter from June the 9th, on the second page of that, up at the top, there's five bullet points. And what we've done is we've used the provisions in the state act that allow us to create what are called special districts. And Planned Unit Development District, the PUD district, is a special district. It's one of them. That's in the current ordinance. As well as the Hamlet Center District and the Research and Research Applications District that are currently in the document. What we did is we basically folded all of those districts into this new Article 50 called Special District Regulations. And so the purpose statements, the intent, the language that Don mentioned, the intent to identify special areas of the township that have a set of rules that apply to them that reflect their character as a unique area of the township. All of that is now incorporated into this Article 50 and these five special districts.
Okay.
And so it is carried through in this new Article 50.
So we list the, I'm just looking, okay, so 50.3 explains the standards related to the planned unit development district, special district. And 50.302 is the urban services special district. And there's subsections under that. And 50.303 is the research and research application special district. And then 50.304 is the Hamlet Center special district. So we have at least four in a residential office park special district. So we've got 5 special districts there called out. And is it the zoning map that designates where those are in the township, or is it something in the master plan?
Each one of these, the development review process will be the same as what would have happened in the old planned unit development. It is both a rezoning and a development plan that come before you, what this ordinance calls an area plan. It's essentially a concept plan for the development. So if a developer wants to move in, wants to build in what will be called the urban services district, if this ordinance is adopted, they would present to you both a rezoning application and a concept plan for what they propose to do. And you would be holding a public hearing and then making a recommendation to the board on both of those elements, both the proposed rezoning and the proposed area plan for the project. And if the township board approves what's brought before them, the area plan, that concept plan for development becomes part of the zoning of the property. And so it is identified, if it's approved, it's identified on the map as being the urban service district or whichever district it is that they are asking for. But there is also that area plan that is actually part of the zoning of the property from that point.
Okay, so, does our zoning map presently have a planned unit development special district?
I don't believe so.
Okay, so that's like a provision for us to enable that. In our, we have a master, as part of the master plan, right, there's gotta be a map that designates an urban services district. And I just don't know where the page is, right, I'm trying to find it, but I know there's a map that designates, this is an urban services district, and there are different elements of urban services type development called out in there, because I know there's a residential office park called out in that master plan, and a number of things. And so I'm just trying, and the only reason I'm asking the questions is I wouldn't want to somehow get out of sync as we were transitioning to a new zoning ordinance. And then, you know, eventually, a year from now, we have to be taking a new look at the master plan, but I wouldn't want us to be uncoordinated in the time it's gonna take between when we end up revising the zoning ordinance and when we actually deal with the master plan.
Actually, the proposed ordinance improves the coordination between the zoning ordinance and the master plan. The proposed ordinance actually improves the coordination between the ordinance and the plan. Actually, in our report, the June 9th report, the little map that's down at the bottom is that urban service map you're talking about. It's map 19, and it's in part 10 of the master plan. That's right. Yep.
I finally found it. That was just, you know, I don't have it tabbed.
And this proposed ordinance references that map, as well as referencing part 10 of the master plan specifically, so that development projects that come before you in that area would be required to be consistent with the master plan.
Okay. All right. And then, you know, the only other point that was made by Ms. Petrosky, and it's a fair one, is with the exception of Commissioner Can, no one else here that's on the planning commission or supporting us other than, let's say, Mr. Pennington, was involved in the changes that were made in 2005 and 2007. So it's not like we have the history here, and I think that was kind of the context as to some of the pointed questions that were here. Okay. So, that's all I intend to cover on Ms. Petrosky's note. And I want us to move on now to questions and comments and concerns from the members of the Planning Commission related to any content in the proposed zoning ordinance, or, you know, and it can be related to the way we made the editorial changes from the last meeting or anything like that. But, you know, because there's plenty of work going on, and I'm sure someone has some questions or comments.
Can I have 45 back, please?
Pardon?
Article 45. Can I have that?
Oh, you want 45 back?
Yes, thank you.
Okay, so who's got something to share? Or something as a question?
The,
Okay, there was, maybe I'll help people. There was a section in the zoning ordinance changes where we had a question as to how to handle screening and setbacks.
that was my.
Oh, are you ready to
I was
go?
gonna talk about screening, with the Chubb Road people. You know, in here, I look at that, that's all well and good, but I can't see, unless somebody really can explain it to me, why, if they were to put an addition to an existing building, why they have to screen when they're not screening now. Why can't that be like, I don't know if you want to term it grandfathered, it's, if a new company comes in, then they should have to abide by all the new rules we have set. But to take an existing business and make them screen, don't make sense to me. Especially if they put an addition on. Unless I missed the boat somewhere, but I just don't understand that part.
So you have a specific question?
Why does a current business have to screen a new section of their business if they put an addition to the building? Because that was talked about here.
Okay. One of the professionals explain it. I mean, I could try, but I'd rather have a probe it.
The requirements basically, one challenge we have is, because I certainly understand your point. We want the existing businesses to grow, we want to support the existing business community to be able to improve, and we certainly don't want to create a circumstance where we're putting onerous conditions on their ability to do that. The challenge we have is we do have to apply our standards evenly. And so we don't have an ability really in the ordinance to discriminate between somebody that's been here for 20 years and somebody that's just bought a property and wants to develop, with a couple of caveats to that I think will be helpful here. Somebody that's developing a vacant piece of land in the general industrial district would have to go through the full site plan review process, just as any other developer developing a vacant piece of property. And all of the standards of the ordinance do apply to that, without exception. So stormwater management and screening and all the details have to be dealt with when you're developing a vacant piece of property. When you're, as this ordinance is proposed, when you're making changes to an existing site, like a building addition, or even a new building, or an expansion, maybe you're adding land area to an outside storage or whatever it might be, then there are a couple of things that come up. First of all, we've added or proposed to add what's called a minor site plan review process, and it's kind of like a light site plan review. Much less information is required. They don't necessarily have to have engineered plans if they can show, if you find it acceptable that you understand what they're proposing. They can literally draw it out and bring that to you. That minor site plan process is actually intended for things like building additions and such, and changes to existing sites that don't involve a lot of grading or moving of material around that might require an engineered plan. The other thing that comes up that I think is important, maybe we take a look at that. It's towards the end of the document. It's Article 65. And that is, it's on page 13 of this article. And it's called, it's section 65.09, called non-conforming sites. And this is a new section proposed in as part of this update. And it says the purpose of the section is to encourage improvements to existing sites in the township that were developed before the current ordinance standards were established. The section establishes priorities for improvements to existing sites that are intended to gradually bring the site into compliance. And then the most important line here is the last one, this first paragraph. Non-conforming sites may be improved or modified without a complete upgrade of all site elements subject to the following conditions. What this basically says is if you have have a site in the industrial area, any non-conforming site, but let's use the industrial area as our reference, that was developed at some point many years ago, long before the screening requirements were put in the ordinance, long before whatever the ordinance elements are in there. If the owner of that site would like to make improvements, they'd like to add to a building or whatever improvements they might have that trigger a version of site plan review, whether it's a full site plan or that minor site plan process. You as a planning commission, they as an applicant can propose to bring that before you without necessarily bringing the entire site up into compliance with our current ordinance, because that would be onerous. That would be very expensive and really not, if they're proposing building addition, it makes no sense to require them to put screening around a 30 or 40 acre piece of land. And what this section says is, first of all, that public health and safety deficiencies need to be taken care of. So whatever those might be, maybe they don't have a good defined driveway at the road, and so ask them, can we define a driveway space so that we don't have vehicles entering and exiting this property all over the road frontage, but narrow it down to a defined area, if that's the problem. It might be lighting, maybe there's a problem at night, because there's a lot of trucks that that are driving overnight. Can we put some lighting there to make it easier to see the entrance and see vehicles that are going in and out of that site? Whatever it might be, sidewalk to the building, maybe they could put in a handicap accessible sidewalk if that's appropriate. Whatever those public safety deficiencies might be, if there are any, they're asked by this section to take care of those. And then there's a menu here in item 3, which wraps over to the next page. Item 3, there's A through J of other things that could be done. And basically this section says, can you do 3 of them? And there are things like preserving natural features, if that's appropriate on the site, pedestrian access improvements, we just talked about, a barrier-free ramp to get into the building, changing the sidewalk so that somebody in a wheelchair could get into the building. Vehicle access and circulation, we just talked about that one as well. Building design or exterior facade, if they're putting a building addition on, they may be painting the building, which that would take care of it, something that just improves the building system. Off-street parking or loading improvements, landscaping improvements, screening improvements, exterior lighting improvements, drainage improvements, and then cleanup or restoration of a blighted site, removal of contaminated soil or similar environmental improvements. Basically, these are things that the applicant can decide which ones are best, are most appropriate for them. None of them are intended to be large, and in fact, item 4 there, right after that list, says the scope of any site improvements requested by the Planning Commission shall be reasonable proportion to the scale of the construction of the proposed building improvements, expansions, or other improvements. Basically, you're required to make sure what you are asking of them to do, of those 3 things, are as reasonably in proportion to what they're proposing to do with their building improvements or other activity on the site. So this section allows you as a Planning Commission to review a plan for an improvement like a building addition without bringing the full weight of the ordinance down on the property owner. It asks them to do some things to improve the site, but it gives you the ability to approve a plan that doesn't meet all of the current ordinance requirements. And that is a significant change related to dealing with existing sites. And this is a section we've used in other communities to make it much easier to work with older areas of the township, older development sites, where you want to see things happen and where you want to support business growth. This is the section that allows you to much more easily do that.
Okay.
Okay. I'm still open to questions and comments here. I'll look at my list here, and one of the questions I'd like to get into is we had a question related to the let's call it interplay between residential uses and industrial uses in the general industrial district. And how we set the rules so that those incompatible uses can coexist in with the situation we have there, right? So the first question we had, I thought, was what's the inventory of properties that have that situation in our general industrial and light industrial district? And you guys did that, right?
Yep, did everybody get a copy of this little map that we put together? Forgive me, my colors are not true. My printer ran out of coloring. But we did review. Donna went through the assessor's record and provided us with a list of what the assessor shows as the existing use of these properties in the Chubb Road industrial area. And we used that then to create this little map. And on your color map, the yellow parcels are the ones that are both single-family residential, where there's an existing home on the site, and have a 100% homestead exemption, which means they're owner-occupied housing. And in this area, the immediate area we're talking about, there are basically 5. There are 3 that are clustered up at 6 Mile right by the railroad tracks. There are 3 small parcels together. And then there's a 4th one north of the railroad tracks, and a 5th one on a small parcel just south of the railroad tracks on Chubb Road. The additional parcels, the ones that are in orange, are properties that are currently used as a single-family residence, but they are not. They have a 0 homestead exemption, which means they're rented. Somebody else owns them, but they're rented properties. And then there's one red one up there on 6 Mile, which is the mini self-storage warehouses that has a residence associated with it. So really, in terms of the properties we were looking at protecting, we were really focusing mainly on those owner-occupied. They were the ones we were most concerned about. Because the other ones are essentially owned by people that also own the industrial parcels in the area, so they're more likely for investment purposes long term.
He's wrong.
Yeah. Well, I had a question related to the accuracy of the map. Okay, because I actually went out and tried to correlate the lots with, seeing them, and when I was at the corner of 5 Mile and Salem, I would have thought that the parcel identified 9515 5 Mile was a residential use.
Well, actually, I did not. What I will say is I did not include those because they don't directly abut a property that's currently used for industrial. You're absolutely right. There are residential uses over there. But I left them out simply because they were, while they are in the district, they're out of the immediate area of Chubb Road that we were talking about.
They're not adjacent to the general industrial?
Yes, they are. But like I said, because they were out in sort of the corner of the area we were referring to, I did not identify them.
Yeah, that's okay. That's okay. And because there's, I think there's a small lot just east of that that's also a residential use. So, and the way they are right now, I mean, they're basically, I mean, I certainly know that the small lot east, the lot between 9515 and 9535, which is whatever the number is, it's not, the map's not big enough to tell you the number, but it's there for sure, okay? That lot exists in close proximity to the industrial use on 9535, and I don't see any screening there at all, and that's just the existing condition.
Excuse me, that's both the same piece of property. That's Bowie. That's Virgil Bowie's property, and that's his piece of property. That's 2 pieces, not 2. That's 4.1 acres next to 9515.
Oh, okay, so that's
that
a
actually
mixed,
belongs with that
it's a
fabricated
mixed
shop.
use property.
It's a house like like the warehouse,
Yeah,
the
okay.
self-storage
I have
warehouse.
all that right here. There's more than one, there's more than what you said.
Yeah.
It's right here with everybody's name on it and what it's used for. And I went and researched in downtown Ann Arbor, and I have 6 of them for you to look at. There's only 2 houses that actually account for homestead. And I'd like to give these to you, but I got this map late on Friday, which we should have had before that. And I went and made all this out.
Okay.
So
So,
rather than you look at it, I'd rather give you.
yeah, you're welcome to pass that out. I think that, is there a discrepancy between the maps?
Anything in yellow is homestead.
What we ought to do is at least understand which is accurate.
These are the only 2 on Chubb Road that are homestead. Right? This is urban. Look at this piece of property on both sides. He bought it for.
Yeah, okay. I've got those, here's one for Casey.
And then the second page actually shows my piece of property surrounded by residential.
Yeah, okay. So if I look here,
That's
I see the 9515, and I see the,
Yeah, that's what we should.
so 7572 corresponds, 9515 corresponds, the 9535 we just talked about, so it's basically the same. 9751. Oh, there it is, okay, yep. Yep, so that worked, that correlates. And then the 7374 correlates. And then the 7380, that, to me, if I recall, that's almost an empty boarded up house on the front of that property, which is shown here as 10044.
The last lot on Salem Road is that house with a lake in front of it. That's
No, I'm over on Chubb right now. Okay.
You 7380, that's a rental house on a piece of rental property that's got 3 industrial buildings. I have a picture of it from the air if you want. And
Yeah, but, okay, but is either 7374 looked to be in use and 7380 looked like it was empty.
It is empty. It is empty.
Yeah, that's empty.
But that's on a property that's kind of a mixed use,
Yeah.
which makes it similar to the 9535, okay? And then we go up, and we've got 7742 correlates, 7750 checks, 7800 checks. We go up to 6 Mile and 10124. We understand that one, that's pretty simple. And then, when I go west on 6 Mile, I see 9786 cross checks. And I see 9822 cross checks. I just don't see 9810 in the
It's a
middle
little
there.
cut out
It's a
on
little
one
teeny-
parcel.
It's a very small lot.
Yeah, okay.
Yeah, it's a very small lot.
It actually is in front of this one.
Okay, so, but,
Here's the one.
there's the picture.
A picture from the air of this.
Yeah.
That house it's got storage behind it. It's an RV, it's all paved right now.
Yeah, this house is used, and it looks like it's used as a residence, and then, but I was commenting about this one,
It's empty.
which looks like it's vacant.
This is all asphalted right now and it's being used for RV storage.
Mm-hmm. Yeah, okay. So, I think we have an accurate inventory, because I just correlated yours to the one Mr. Nanny provided, and they seem to be saying the same. So, we realize we're not talking about different sets of information, and now really the question for the planning commission is, what do you do about managing those mixed uses?
Look on the second page, Mr. Shepherd. There's 2 pages there, look.
I'm sorry?
There's the second page.
Okay, yeah, well, Okay, you're listing the owners perhaps of the
No, the ones that
property.
are beside,
Pardon?
the ones that are beside those pieces of property,
Yeah.
me. Mr. and R&R Haley Hall, next to a rental house.
Mm-hmm. So again, the question is in front of us that we had last time was, we said, how do we handle the interaction and with the ordinance, and what was the size of the, let's call it, potential incompatibility, and quite honestly, I don't know that we have a problem with things the way they are today. Right? But, so what we don't want to do is create a problem with the new zoning ordinance, right? And that's been our intention all along. And the question is the way this is worded, are we likely to create a problem? And then the other question is are we doing the right thing for the township? Okay. And so, who's got the insight here to help us piece together our direction on this? Mr. Can, you almost look like you've got a way to analyze this.
Yeah. See, I want to express it. Well, if you'd like, I can basically give you a quick overview of what we did here in this July 5th draft.
Yes, please do that.
If you look at the July 5th draft, if you turn to the outside storage general section, which is page 40-46 in the set of materials, about 3/4 of the way back. Further, from the discussion from our last meeting, the direction that you gave, we updated this section, and the first thing we did is we made the changes that were agreed on, and then we moved. What we did is we moved a provision for screening existing residential uses, which are these ones we're talking about here, these 100% homestead properties. We moved that into this option. So if you see at the bottom of this page, you see that this option that's in the little text box there. If you choose not to include this option, then the new ordinance would only require screening between districts. It would require screening between the general industrial district and an adjacent residential district or an adjacent rural district. But it would not require any screening for the existing residential uses. So without this option that's in the box, we would essentially be following what the current ordinance does. Because the current ordinance does not require any screening for existing residences that may happen to be the district. We put this here, and then also basically the same language is included in the next section, which is self-storage warehouses. So whatever we do here with outside storage policy-wise, whether you include this option or not, we'll carry that through for the other industrial language.
Okay, so, which leads me to a question, and that is under the current ordinance, there's no screening required.
For the existing residences, right?
Right? And under the current ordinance, what's the setback between those properties on that lot line?
There are yard setbacks required. And actually, the ordinance, I believe, actually says, this was a point of contention, the ordinance says that outside storage has to be outside of the setbacks. But that was a point of contention related to whether, what was supposed to be in that 2001 document. But it is in the document. It says that the screening, the ordinance, the outside storage has to be outside of the yard setback.
Okay, but when I say current ordinance, I don't mean current draft.
Right.
I mean the ordinance that's in effect today. We have side yard setbacks on that restrict use 30 feet or 50 feet in GI.
I think it's 50 feet, if I recall correctly.
50.
And I know we went through that because that was a big discussion point with side yard setbacks and outside storage. I think so. I mean, I can remember devoting at least 3 hours to discussing that subject over several meetings, right? And what I just don't remember is where we are today. No, that's the,
That one or
that's
no?
the draft.
Okay.
But what I'm looking for is this ordinance.
He's talking about the existing side yard.
And I'm just trying to understand where we came from. Right, GI is Article 41, right? So I'm gonna look, if you'll put up with me for a minute. Okay, I will read from Article 41 of the current zoning ordinance, and it says, it has lot area, lot width, lot coverage, floor area ratio, yard and setback requirements. Front setback not less than 85 feet. Side setbacks, least width of either setback shall not be less than 50 feet, except in the case of a corner lot where the side setback from the road or street shall not be less than 60 feet. The rear setback not less than 50 feet.
No, right, but the building setback is 50.
So if I'm trying to understand today, what situation you have when you have residential use adjacent to a general industrial use, there's no screening required today, but the general industrial use stops 50 feet from the lot line. Unless it's been grandfathered or otherwise approved as an exception, correct? If you read, if that's what the ordinance says.
No, it's just a
I
building.
think.
Yes.
Here, what it says in the current ordinance related to storage of materials, this is section 60.04 of the current ordinance. It says, any lot or parcel in any industrial district, the owner or tenant shall locate and store such materials within an enclosed building or where outside storage is permitted, within an area surrounded by a solid unpierced fence or wall at least 7 feet in height and no less than the height of the material stored therein. And it says such fence when adjacent to a non-industrial district shall not be closer to the lot lines than the minimum setback requirements for said district. So essentially it says that if the property is next to a residential or a rural district, they have to set the fence back outside of the yard setback, outside of the 50 feet. So they can't put any storage, outside of the fence. That's only where you're relating to a non-industrial district.
Yeah, okay, so, and I missed one point here, right, because we call, in the current ordinance, it does say you need a transition strip at least 20 feet wide.
Right, and section C of this same section talks about outside storage materials shall be subject to the following regulations. And it says such storage shall not be located within any required transition strip or within the area between the front face of the building is extended across the entire width of the lot and the street right-of-way, except in the general industrial district where such storage should not be located within the front yard setback or within any required transition strip.
Okay, what section is that?
This is still section 60.04 of the current ordinance, the one that's in force right now.
60.04 also touched on it.
It's on page 60-17 to 60
No, I know. Yep. Okay. So what we have today, well, you just read it, right? That's what's required today. That may not be, when you talk about outside storage, that's what's there.
That's what's required right now.
But the use itself, right, other than the outside storage here, which it offers greater provision than what's in the section on general industrial, right? Right, for that particular use, right, of outside storage, it allows you to use a larger footprint, right? But now, the proposed zoning ordinance, we need to talk about the condition of, if here you have this residential use and outside storage, which in general industrial outside storage could be cranes, right?
Cranes or large piles of gravel, whatever.
All kinds of stuff. And we've now said, potentially, right, we talked about residential districts adjacent to general industrial and how we want to manage that. And the question is what do you do when you have an existing residential use in an industrial, in a general industrial area? And today, we're supposed to be 20 feet back of the fence or the lot line, right? With this, and what I don't want to do is, I don't want to, this is just me personally, but I don't want to write an ordinance that says, well, okay, you can, just because there's a house there, now we can encroach an additional 20 feet. That it allows somebody to change the status quo. Without some provision for taking and encroaching that extra 20 feet. Now, maybe to some residences, you know, because I've looked at some, there's one house there where, geez, the setback from the side yards is probably 200 feet. Okay, maybe more. That's the property at, it's on Chubb Road anyways, it's the northernmost property on Chubb. And it's like, 20 feet in the side yard, it probably wouldn't matter to that person because the residence is a long ways away and it's just grass he seems to mow, you know? But if you look at some of the others, they're adjacent to what could be intense uses in this, and then residential use, the side yard setback isn't that much. And so I'm just kind of articulating for the rest of the people here on the planning commission and professionals and you guys that there's a handful of instances where that's there. And I feel we just need to be careful as we go through this so that we have our eyes wide open when we say this is the way we want to handle it. We don't want to force people to change what they're doing, but we want to protect people from something intrusive happening, I think. But I don't know quite how to do that.
They're non-conforming.
If their house goes up for sale, they're most likely gonna be bought by a business. They're gonna tear their house down for a bit and usually put something up there.
Make it an office.
They're making an office. That's what happens out there.
Mr. Shepherd, I have a house on my property, a 2,400 square foot trailer. There's one next door to me too.
Virgil,
That's
he has a house.
Stonti.
Well,
Everybody has, they're just rental homes.
but, okay, we understand the non-conforming stuff, and just let us work on this a little bit.
What this provision, the text box here on page 40-46 proposes, basically, if we're talking between the zoning districts, we're all set. If we're, you know, the language that's outside of this text box covers interactions between the general industrial district and the residential district next door. That's taken care of. We have the requirements for that. There's screening requirements already in the ordinance. This text box basically deals only with existing residential uses that are in the general industrial district, you know, non-conforming residences, which are the ones that we showed in the map, those half dozen or whatever they are. And this text box basically says that screening would be required along the lot boundary, where in the area of the outside storage that is within 200 feet of the actual residence on the property next door. So in that case you mentioned where the residence is well back from the lot line, that would be a case if it's more than 200 feet, there's no screening required. If it's a case of a very large property, there's one that's large, it's off of 5 Mile, the 9751, that has that long extension that goes up north behind the industrial properties on Chubb Road. For that one, it's well outside of the 200 feet. The actual house that's on that property, 9751, is down the 5 Mile frontage, and so there'd be no screening required for those industrial properties off on Chubb. So it is a very limited provision. It basically says provide the screening if you're within 200 feet of the house, and it wouldn't be required otherwise. But it would provide some protection for those existing residences.
Okay. So when I read what's listed here as the option, it says any area of the storage facility or subject lot that directly abuts a lot occupied by existing dwelling in the LI or GI districts and is within 200 feet of the dwelling shall also be screened along the common lot boundaries per section 60.09D. And maybe what I'm thinking is we only need to invoke that if there's outside storage within 20 feet of the lot line. Because right now, there's a 20-foot buffer that they can't use for outside storage,
The transition
right?
buffer. Yeah, the transition buffer is what you're talking about.
Yeah, there's 20 feet there, there's a transition buffer that shouldn't be used, right? They might be using it, but it's it shouldn't be used if you read the regulation correctly.
It's between two different zones.
Now, the transition buffer in the proposed ordinance also covers land use, so it would apply for residents. So basically what you're suggesting is that as long as the outside storage is not within that transition buffer, to keep the storage 20 feet back from the property, there'd be no screening required. I certainly would reduce the number of circumstances where it might apply. The challenge would be is that there's no real way to enforce it. Because the only way it could be enforced is basically by flying over the property, taking a picture and measuring. Because this is happening well in the interior of these lots generally. I suppose the next door neighbor complains, so they maybe go out and measure from there and see if the material's gotten closer to 20 feet.
There's no storage in the transition buffer, right?
This ordinance allows storage within the setbacks, but doesn't allow storage within where a transition buffer is required.
So requiring some blockage if something is in the transition buffer is basically saying if this guy breaks this rule, then he has to follow this other rule.
I'm concerned that the application may not.
If you don't follow this rule that says you can't put store something in the transition buffer, then you have to put up a fence to protect this guy from seeing it from the residential. If you're not following the first rule, deal with not following the first rule. It's not an if-then clause, right?
I mean, basically what this little text box provision says, that if they are going to do outside storage within 200 feet of the next door neighbor's house, then the screening would be required. Otherwise, it wouldn't. So, in many cases, the property,
We're talking
the
the house,
relationship
not
is
the property.
right. And the reason we're talking about the house here is because no new houses are going to be built in the industrial districts. These are existing houses that are grandfathered in. And so we're saying yes, so we can specifically identify the house and say if it's out more than 200 feet away from that house, then no screening would be required.
So are you saying, as you scribe a 200-foot arc from the house, anything that's within that 200-foot range, that's where someone would have to put up a fence?
That's what we're saying, but that's it. Or other screening. I mean, they could do it other ways, not just a fence.
A bunch of arborvitae's would be great.
Would you folks look at
Or berm,
6501?
or-
6501?
But the current ordinance.
Current ordinance. Current
This
ordinance.
this flies in the face of the current ordinance.
Did you have something to offer, Ms. Hamilton?
Yeah, if you look at the current ordinance, this discussion you're having, it's Article 65. Its title is Non-Conforming Uses, Structures, and Properties. Certain lots, structures, and uses of lots and structures may exist within districts established by this ordinance or amendment thereto which were lawful before this ordinance was adopted or amended, but which would be prohibited, regulated, or restricted under the terms of this ordinance and its amendments. It is the intent of this ordinance to permit such nonconformities to remain until they are discontinued or removed, but not to encourage their survival. And what you're talking about now is you're trying to encourage their survival. It's directly opposed to what the current ordinance says. And I just don't understand why there's such a radical change.
Well, if I may, I can kind of hit on this point. Zoning in general, is an interesting creature in terms of the law. It is the one case where you can have circumstances where somebody's literally allowed to continue to break the law. The law changes, made something non-conforming, and that property owner is allowed to continue to have that, whatever it is, like this house in the general industrial district, for as long as they choose to continue to have it. They are legally protected or grandfathered in as a legal non-conforming use. And in older ordinances, it was often the case that these non-conforming activities were essentially tolerated but discouraged. And in many cases, the provisions were very strict in terms of what could be done or not done to even repair it or fix it as time went on. The goal that eventually it would go away. The problem is that they tend to not go away. They tend to evolve over time, but they don't tend to actually disappear. What happens particularly to non-conforming residences is they tend to become blighted because of the inability to get a mortgage and sometimes difficulty even getting insurance for a non-conforming home. And we talked about this when we were putting this draft together. One of the things we updated in this Article 65, the non-conformity section, was to add a specific, a separate category called non-conforming single-family homes, and put standards in there that would make the mortgage companies comfortable that they could provide a mortgage on that property. And the state law allows us to create, what the state law says is that you're allowed to create different classes of nonconformities and to treat them differently. You can identify, you can say this class of nonconformity is given this set of rules. This class of nonconformity is given this other set of rules. And that's, for example, we talked earlier about the nonconforming sites. These older properties have developed many years ago that are nonconforming with their current site development requirements are nonconforming. But we added this section called nonconforming sites, creating a class of nonconformities that actually gives the township much greater flexibility to work with it. We're not trying to put the hammer down on these older development sites. We're actually saying we'd love to see you improve. We want to help you improve. By adding that section that allows you the flexibility to work with them and not necessarily require all of the, everything in the ordinance to be brought up to code, is part of that flexibility. Same thing here. We've created this non-conforming single-family home category that allows the home to be replaced if it's destroyed. That's the key for mortgage companies. They had to know that if that home is burned to the ground in a fire or wiped out in a tornado, that it can be rebuilt in the same foundation. Without that, you simply can't get a mortgage. And so that class of nonconformities has been added to this proposed ordinance to allow these properties to be able to get a mortgage in the future. So yes, our current ordinance says they're discouraged from continuing. Our proposed ordinance certainly continues to provide the legal protections, but also gives some greater flexibility working with these older areas of the township in a more positive, more cooperative way.
Okay.
Why would you penalize a person that's legal?
That's what I was wondering. Why, I mean, if the intent is to provide for the gradual conversion of such nonconformities to conforming status, why would the burden of that transition be put on another group of people? That just doesn't seem
Why
right.
don't you make the homeowner put the fence up?
Well, and that's a great question. That's really why this was, after our conversations, that's why this little provision here was put in this text box. If it's the Planning Commission's preference, this is really a policy decision of the Planning Commission. If it is your preference to say, you know what, we're only going to require the screening between two unlike zoning districts, and we don't want to provide any additional protection for the existing residences, then we simply just take out that option. We would just don't include it in the document, and then we'll be following basically what the current ordinance does. If you feel like there is a need to provide some level of protection for those existing residences, then that option should be included in the ordinance.
It's kind of like when someone puts up a fence between two, I mean, usually there's typical one aesthetic side and one functional side of a fence. Whoever puts that fence up gets to choose. I'd say take the option out. If the person doesn't want to see that there, they know what the deal is with the house or anything like that. I'm sorry for possibly those owners, but if they don't want to see that, have them put up a bunch of arborvitaes or something like that. So,
I think this would result in a lot more discontent than collaborative.
It's only two houses.
All right, so
Two houses.
I think you guys have done good. Ms. Merlo was trying to get recognized here.
That's okay. I was just gonna ask the planning commission to consider, is it really our role to encourage this and protect these people, or should we be more of let nature take its course? Because I think protecting the people is causing, and interfering is causing more controversy.
Well, I have a suggestion, okay? But, and again, I want to propose a change, or maybe reinforce a comment. We're talking about page 40-46, and I would like the material shown as an option in the box, which is shown as item number 4, which talks about, this is the option requires some screen and outdoor storage from existing residential uses. And when I look at the size and scope of the situation here, I say it's not needed. And so I would like to recommend that we strike that section from the zoning ordinance draft that we have.
I second.
You just want to do a consensus.
Are we in agreement with that? And I want to know, it's on page 40-46, right? It's what's shown as 40.503, paragraph 4, which was an option to have some screening, right? Because we already removed the guaranteed screening, and we said here's some optional screening which is shown in this draft, and I would like to just strike that. And that effectively puts the necessity for screening. If screening is needed, it can be put up by the owner of the residential use.
Yes.
Are we in agreement with that?
I am. Yes.
Yeah, okay, I know, we're okay on the south end of the table here, and is the north end caught up with us?
Yep.
Okay, so it's unanimous that we would like to make that change.
Then under the self-storage warehouses, which
Yes.
is,
So
has
you,
the same
so
option, we'll do the
there
same
won't be
thing.
a four at all, right? But you need to maybe renumber them.
Right.
But that takes that requirement away.
Yeah. And then on page 40-48 for self-storage warehouses, it's the same option, so we'll delete that as well.
Yes,
Yep.
Okay?
yes, I would like that stricken as well. I think that's consistent, I mean, it follows. Okay.
40-48.
There was the optional box there, and that was the text that you would use if you wanted to require the screening, right? So we want to strike that optional box. Okay?
We have one more optional box that's related to this. If we
Where's
turn
that?
About halfway back, it's on page 30-8. This is the section, looks like it has a table at the top and it has an option that's about halfway down. This is the transition buffer language.
What's the section?
It's on page 30-8. It's section 30.203, item F.
Okay.
It's about halfway back to the package material.
So
Part of the
then
material.
I would like,
And what this box says is related to transition buffer specifically. This is something that the attorney for the industrial business owners had noted in his letter. It was not discussed by the planning commission specifically to.
okay, this is the elimination of the transition buffer between the residential use or rural use when you're in the limited industrial and general industrial districts.
Right. So this.
But you still need the transition buffer
Between districts. Yeah, that was,
to a residential district.
right.
Or rural district, but not to the use that's the inconsistent use.
Right. So in this case, adding in this option would be consistent with the policy that you
I
use.
agree, we have to add it in order to accomplish what we want. So I would like to propose that we add what's shown in the option box on page 30-8 paragraph 2, subsection C, that we add that text that's there in blue, which says a transition buffer shall not be required between industrial research and laboratory uses in the LI or GI districts and any existing rural uses or residential uses in the same district. Okay, I think that's consistent with what we've talked about, but are we okay with that here? All right, I see that we've got complete agreement on the part of the planning commission.
Okay.
Okay. Now, I just have a, if you go to page 30-10, section H, the third word,
Thank you.
I think there's just a spelling error there.
Thank you. Typos are corrections, I always appreciate that. That should be rear yard.
It's a rear yard setback, not the rear yard setback. Okay. I don't have any other questions, but maybe, yes, Ms. Cripps?
At your last meeting, you were going to review the second paragraph of section 60.02C.
60 point.
I think that's how we discussed that.
You know, my notes show that they were going to review the second paragraph. You took out the language in the first paragraph.
Yes.
And the other paragraphs.
Actually, I took
Did
that.
you take it out?
I took it out, yeah.
The whole section?
Yeah,
Okay.
Yeah, that's the
Excuse
dust.
me. Sorry, but taken care of.
Okay, so that's been revised. And I believe what we had said was we wanted to see it after we made the changes and just make sure we were happy with it. That's where we struck, let's call it the detailed language that went into the drifting of airborne matter behind lot lines and stuff, and where at the time we said we felt it was more than what was necessary to manage the situation. And I guess, you know, is there anyone concerned about what we've done there?
We were just going to make it state guidance, right?
Yeah, we simplified it.
Right.
Right, and so, you know, we did, we made a note to ourselves, and I saw it in the minutes, right? We were gonna just look at that once we made the change, and make sure we were happy with it, but, so I've got the south end of the table here saying they're happy, and the north end happy.
didn't see it,
Okay, so
sorry.
we're good with that.
Okay, good.
Anything else from the commissioners related to this draft ordinance? If there's no more questions or comments, maybe someone wants to make a motion related to the next steps. I certainly entertain that at this point.
You have a draft resolution. A draft resolution. To forward it on to the board.
Okay. The professionals offered us a draft resolution. And I guess I'll make a motion. Make a motion to adopt a resolution, correct?
Yes.
Okay. I want to make a motion to adopt the following resolution. And it's a bit wordy, so bear with me. This would be a resolution of the Planning Commission to recommend approval of the proposed Salem Township zoning ordinance to the Township Board. And the following preamble resolution are offered by Member Shepherd and perhaps supported by another member. And it would read, whereas Salem Township desires to promote the health, safety, convenience, and general welfare of the residents of the township, to preserve the rural character of the township, and to provide for planned and orderly use and development in accordance with the township's master plan. And whereas the township initiated a process to prepare a comprehensive new zoning ordinance, and the Planning Commission directed the preparation of an initial draft zoning ordinance text, and whereas the Planning Commission reviewed the draft zoning ordinance text during a series of public meetings and directed the preparation of a revised draft zoning ordinance with the draft date of 5/7/2013, and whereas copies of this proposed zoning ordinance were made available for public review at the Salem South Line District Library and the Salem Township offices and on the township's website, and whereas notices having been duly posted and published in accordance with the Michigan Zoning Enabling Act, which is Public Act 110 of 2006 as amended, the Planning Commission conducted a public hearing on June 17, 2013 to receive public comments on the zoning ordinance. Now, therefore, be it resolved that the Salem Township Planning Commission recommends to the Township Board that the proposed Salem Township zoning ordinance be adopted, subject to the following changes, if any, being incorporated in the text of the adopted ordinance. And those changes are the 3 changes we made tonight, which need to be, which can
And I will
which can be
close out.
called out in the end.
Mhm.
Okay? So my motion is to adopt that resolution. Is there a second?
Second. Second.
Okay.
Who said?
Who seconded?
Zero.
Daryl.
Is there any other, any further discussion, or are we ready for a roll call vote? We're ready for a roll call vote. All those in favor say aye.
Do roll
Roll
call.
call.
Roll
It's gonna be a
call.
roll call.
No, but when your name is called, right?
TJ McLaughlin,
Yes.
Casey Kelly,
Yes.
Daryl Lewandowski,
Yes.
Pam Merlo, yes. Art Kahn,
Yes.
Doug Shepherd.
Yes. Motion passes. All right. I'd say we're done with business item 8 and we can move on. We have reports of commissioners and committees. And we must have a Parks, Recreation, Open Spaces committee meeting coming up. It's been rescheduled.
Yes, we're tentatively scheduled for July 31st, but I have a member who can't make it, so I will be contacting the members to reschedule that date if possible.
Okay.
Also, we had 2 members who went to Frankenmuth for a training session. Casey has brought back the information on that session, and I will make copies and we'll have it next meeting. The information to finish that session.
Okay. I'd like to ask a question of the professionals while they're here. This was something that was brought to my attention, and that is I was driving down North Territorial, and there's a tremendous number of seismographic sensors that have been sent out in an array. And someone, not myself, made a call to the county to find out what was going on. And of course, it's seismic exploration related to recovery of gas and oil, and perhaps seeing if there's any potential for that here in the township. And so the question comes up is, how does the township and or the state regulate oil and gas well activities, right? And when I took a quick look at our current and proposed zoning ordinances, we talk about extraction operations, but they talk about minerals, not about oil and gas. And so, is it just the state that has the regulations plus our general provisions of our zoning ordinance?
Right. When it comes to oil and gas exploration in particular, the township is prohibited from regulating it in local zoning. It is expressly taken under state control for that. We have, when it comes to sand and gravel extraction, we have partial authority over that activity, which is why we have an ordinance for it. But we don't have full authority over it. The state also retains some authority over sand and gravel extraction, but they retain complete authority over oil and gas. Right, yeah,
quickly.
right, they don't even have to have any local notification related to that. For example, the other issue we have that's related to this is pipelines are being constructed in the area, and in that one, the township has a very limited scope. Basically, if they're building structures or something on the surface, the township can require at least a review of that at the local level. But most of these activities that are truly intergovernmental related, they're crossing county as well as township boundaries and covering large areas. The state retains most or all of the authority over them.
All right, thank you.
There was by the way, on that topic, there was a nice article on AnArborr.com just the other day about property in Saline Township, where some property owners have been dealing with this issue, and particularly a property owner that did not want to be part of an oil and gas exploration area, but was essentially compelled to, because the state, when oil and gas is found and an explorer sets up operations to extract it, they're required to create a minimum 80-acre area that will be affected by it, but also has the potential for those property owners to gain some benefit from the extraction, financial benefit. And this one property owner did not want to be a part of it, and was essentially compelled to be part of it because of how the state law works.
Okay, anything else for reports? I don't think so. So, the next item is approval of minutes from June 17th, 2013. Is there a motion from commissioners?
I make a motion to approve the minutes of June 17th as submitted.
Second? Casey, okay. All those in favor say aye.
Aye.
Aye. Any opposed? Motion passes. We've approved the minutes. I'll also mention that we have a couple of copies of the approved minutes from the April and May meetings on the back table if you haven't had a chance to see them. All right, down to item 12, which is public comment. Any public comment?
Thank you. I have a totally unrelated question, but while they're here, since you're asking about the oil and gas authority the township has, how much authority does the township have over the landfill's operations? Any or zero, none?
The landfill historically has come to the township with what they wanted to do, whether it's buildings or opening up other areas for landfill, etc. As far as actual regulation, very, very few.
We have a host agreement.
Oh, there's an
Yeah,
agreement.
there's agreements.
Essentially, the landfill operators can voluntarily enter
Because
into.
the reason I'm asking is that I have a potential concern eventually with them. And they're building a new cell right adjacent to me. And I have no problem with the noise, I have no problem with the dust, I have no problem with the smell. The problem is, once they start dumping in there now, they've come close enough to me and the owner across the street, they've been coming closer lately. And twice a year, or certain times a year, the birds, the starlings, there's thousands of them. And they just basically crap everywhere. And so I don't know if I have to talk to the county about that, or, I mean, they can go ahead and do what they do, but I don't know how to control that problem. My neighbor's house is across the street, they just get driveways, cars, everything, you're just, I'm not wiped out. So I just didn't know if.
There's not a whole lot. I mean, nothing locally at township level coming down. I'm not sure that even the landfill could affect what the stores are doing.
Brett, are they aware of that?
I don't think they are, because it just changed ownership again, I believe, right?
I mean, it certainly may be worth talking to landfill operators, because if there's something they could do to keep them off their migratory.
Okay, any other public comment? That's the end of public comment, and we're adjourning at 9:20 p.m. Thank you all.
What's next? Retired.
Well, what did you say?